So Peru and Rita, you up first with 2 sub-questions regarding the treatment of wounded and sick. The first sub-question I would like to ask you is the following. What are the parties' obligations in relation to the treatment of wounded and sick people under the international humanitarian law of non-international armed conflicts?
Good afternoon. According to Article 7 of Protocol Additional 2 and also according to Rule number 110 of the Customary Rules of International Humanitarian Law, the parties to the conflict have the obligation to respect and protect the wounded and sick. This obligation is set regardless of the fact whether they have taken or not part in the armed conflict. This obligation has to be carried out without any adverse distinction to the wounded and sick. Also, under customary IHL rule number 110, each party has to, with the least delay possible, take all possible measures to search and collect and evacuate the wounded, sick, and shipwrecked in the respective circumstances without any adverse distinction. Thank you.
Thank you. And now for the second sub-question. Who benefits from this treatment and who does not?
Provided that they refrain from any act of hostilities, all the wounded and sick, and this includes members of each party to the conflict. According to the Jean-Pictet commentaries, non-adverse distinctions shall be made, and this means that the parties to that conflict cannot refuse to treat the wounded and sick of the adverse party. This medical care has to be given in the fullest extent practicable and with the least possible delay. Thank you.
Okay, thank you, Rita, for your answer. Based on what you just said, I have a question for our experts, and I think this question will be for Françoise. Rita explained very well that no distinction may be made between wounded and sick people on any grounds other than medical ones, but it is still unclear to me who is covered by the definition of wounded and sick. Does, for instance, the wound or sickness need to be connected with the armed conflict for a wounded or sick person to benefit from treatment under IHL? So, Françoise, could you tell us a bit more on this topic? You could maybe add arguments on why we do need a broad or restrictive definition of the wounded and sick from your field experience.
Thank you. Thank you. I think it's a very good element, maybe not out of law, but out of experience. The question of the connectiveness of the wounded and sick to a home group or even to the military is essential for the sake of, especially in non-international armed conflict, of making clear that these people are protected because they are sick and wounded, and they should not be first considered as criminal, because members of the non-state armed group will be considered as criminal for taking part in the hostility under domestic law in such conflict. So it is quite important to make sure that the category of wounded and sick do protect all those people from the broader category of, I would say, criminal under domestic law for the one who have taken part in the hostilities. Having said that, it is clear that people that are sick and wounded with no connection with the conflict remain obviously protected both by international humanitarian law because of this non-discrimination system that has been set in place by humanitarian law that try really to extend the protection to the global category, but for sure for the most vulnerable part, which is the people that have taken part in the hostility, but making sure also that there's no discrimination and no priority given to the people that have some kind of hierarchy within the armed groups versus the civilian. So it's quite important to maintain a balance, because from the experience we have very often the fact that when there is a conflict, the whole health system will be diverted, I would say, to help first the one who take part in the hostility and that are wounded or sick, and there will be kind of denial of access to the civilian, I would say, sick and wounded. And there is a second part of danger and vulnerability from mainly the governmental side, which will tend to consider the wounded and sick from a non-state armed group as criminal, and they will use their prerogative as a state to interrogate, arrest, as has been really witnessed in the Yemeni situation very, very often. This mixing of prerogative from the authorities acting as law and order, I would say, enforcement bodies, while humanitarian law try really to cover and to protect the sick and wounded through medical ethics that allows no distinction, no discrimination, unless the one based on medical needs and medical emergency, meaning that the military or the armed wounded should not take precedence on the civilian, but also they should not be disregarded. So there's two sides of vulnerability that are trying to be addressed by international humanitarian law regarding this category.